Okay. Good afternoon, good morning, good evening, wherever you may be listening to us. This is Dr. Askun here. Thank you again for joining us today. Today is another beautiful Wednesday. Please invite your friends, family, colleagues to join us as we start a new edition of our podcast on another beautiful day. If you have questions, start sending in your questions as quickly as possible so that you stand a chance of getting your questions answered. As you probably already see by my dressing, I'm not in court today, but at the same time, I have lots of appointments. But we are going to try as much as possible to answer as many questions as possible today so as to compensate for when we didn't have enough time. Okay. As usual, we talk about current trends in immigration law under this new administration before we go into the questions and answers. Not a whole lot happened between last week and now. The only thing that the DHS announced that has changed recently is that on 17th, today is 19th, I think. So 17th will be Monday. Okay, yeah, on 17th, which was Monday, DHS published an agreement between the United States government and the government of Ecuador relating to transfer of third country nationals to Ecuador. So, if you are ordered removed now or you are picked up and they decide to deport you, even if you don't have a valid passport or if they cannot determine your nationality, or if your country is not willing to issue a passport or travel document, with this arrangement, with this agreement, it is possible that they will send you to Ecuador. The government of Ecuador has signed an agreement with the United States to take people from third countries, meaning non-Ecuadorian citizens. I hope there's something like that, Ecuadorian. Okay, just making sure. Okay, so that is one thing. Then there's another thing that I want to talk about, and that this is not published anywhere. It's a trend that we have seen in our office and have been observing. And I've also heard about it from other lawyers, from American Immigration Lawyers Association, and some other people. It's a trend with this new administration. And I want to warn our people. The trend is that now, whenever you file any application for adjustment of status that is family-based, if you have been previously married to a U.S. citizen, it doesn't matter how the marriage ended. It doesn't matter whether the U.S. citizen filed a petition on your behalf or not. The trend that we have seen is that DHS investigators are going back to talk to these U.S. citizens, these prior spouses. They are going back to talk to them. I don't know whether they are threatening them. I don't know what conversation they are having with them, but we have seen the trend is increasing. We have situation of somebody who married a U.S. citizen and nothing was filed. They didn't file any paperwork. They didn't do anything. The marriage lasted for about a year. It didn't work, and then it ended in divorce. Guess what? DHS investigators still went to this American citizen spouse to ask whether the marriage, even though she didn't file anything, but why did she even enter into the marriage in the first place? So this is a common trend nowadays. We have seen it in notice of intent to deny. We have seen it in request for evidence. We have seen it in different forms. This is something that is going on now. Why am I saying this? If you are a foreign national and you are here in the United States, and you have applied for adjustment based on family petition, or you have previously married a US citizen, whether the person petitioned for you or not, it is important to keep a good relationship with your prior spouse, because now whatever they get from them, they are going to use against you. Even though this is not really fair, because any marriage that ended in divorce simply means that the marriage was not working. And if the marriage ended on a bitter note, the possibility of the prior spouse saying negative things about you is very high. Of course, most human beings, by nature, we are vindictive by nature. So if you are in this situation, if you know you are affected by this, you may want to find a way to make sure that you maintain good relationship with your ex-spouse. It doesn't matter if the divorce, if the marriage has ended or not, but I mean, I can't tell you more than that. It is important, but it's a trend that we have seen now, and is we are seeing it on daily basis. And that is why I want to put that out there. Okay, let's go into questions, please. At least we want to spend a whole lot of time today on questions. And for those who think that we are selective with our questions, no, we are not. We are answering questions in the order in which they are received. You see, this is a live program. You can also follow the questions. You can see the questions yourself. So you will know that we are not selecting questions. We are answering every question in the order in which they are received, at least within the limited time that we have. I know that even if this program lasts 3-4 hours every week, we can't finish answering questions because people will always have questions. So we try as much as possible to answer as many as we can without being selective. Okay, the first question today. What? Oh, okay. So yeah, if you have questions that we didn't answer last week, I hope those who asked the question are online today. And let me ask you, when are we going to announce the free consultation? Is it this week?
It's next week, right?
Next week, okay.
Yes.
So we want to start with the questions that were unanswered last week.
So
Again, the question is, can I file afresh from another new EAD because I'm out of status and perhaps with a green card? I didn't understand the aspect of with a green card. Is it as in applying for somebody with somebody who is a green card holder?
No, it sounds like they don't really understand the process and think that they can file an EAD without the green card application based on VAWA. That's my understanding.
Okay, let me answer the question the way I understand it. First and foremost, if your VAWA was denied because your previous divorce document was questioned, no matter what you file, they will still deny it. So the starting point is to go back and fix that divorce. Now that you are now residing in the United States, it is better that you file a new petition for divorce here in the United States so that you clear that issue. Without clearing the issue, even if you marry somebody else, it's still going to be the same result. So it is important to clear that. So I'm assuming that you have already been divorced from the abusive woman you are referring to here. But if not, you will need to do that divorce. You will need to do a divorce of the previous marriage. So once you clear those two hurdles, then you are at liberty to remarry and then go ahead and file a new petition and a new application, and you will now be able to apply for employment authorization. but you cannot apply for a standalone employment authorization, especially because the underlying petition, the VAWA petition, has been denied. Okay, the next question is the next one.
Sorry, they're photos. It's not. So the
That's what I
next one,
discovered.
this
Okay,
one.
thank you. Good afternoon, sir. In filing adjustment of status, approved NIW. Well, in filing adjustment of status, approved NIW EB2 with family, is marriage certificate copy over many years okay? It must be authenticated from Nigerian country. Thank you. Well, it depends on the type of marriage. If you married under the act, if you go to the registry, yes, you need a marriage certificate issued by the registry, by the civil authority. It doesn't necessarily have to be authenticated, but you need a marriage certificate that is issued by the civil authority, the registry where you got married. That will be enough. But of course, if your marriage is not a registry marriage, that is where you will need well, it depends on the marriage. If it's a church marriage, most churches issue marriage certificate. If it's an Islamic marriage in Nikai, most Islamic marriages they issue marriage certificate. The only one that does not issue marriage certificate is the traditional wedding. And for that one, you can do a declaration of marital status affidavit. That will be enough. The next question, I'm assuming this wildlife. Okay, thank you. Good day, sir. I have a pending marriage-based adjustment since 2019, and the status still shows pending review. What can we do to get someone to act on the application? We have called them several times. Well, do a service request. If that one is not working, my suggestion would be congressional intervention. You and your U.S. citizen spouse should identify the congressman representing your district and go to their office and seek help. Most congressmen, especially Republican congressmen, they are very effective. I mean, they will contact immigration on your behalf. After you give them authorization to do so, you will sign a written permission for them to discuss your case with USCIS. And once they contact USCIS, they are pretty good at getting results. So that may work. But if that doesn't work, your final option will be to file mandamus. But as I always tell my client, mandamus should be the last consideration because he who lives in a glass house does not throw stones. So if your house is not in order and you file mandamus, it can backfire. Okay, the next question. We are still discussing questions from last week.
Okay, so the next one is this one, the brown.
Okay, thank you. USCIS asked me to submit marriage certificate that has seal. The Mushin local government I submitted as just stamped. What do I do? Well, stamp is also considered as seal, but what you should do is to request a certified true copy from the registry. You should request a certified true copy.
Yes, that one. Yeah.
The next question from last week. Thank you, sir, for all you do. Can divorce affect removal of condition of a green card holder who got it from family-based application? She has applied for removal since 2024 July. Well, this question is not complete, but I'm going to try to complete it the way I know how to the best of my knowledge. I'm assuming that this removal of condition of okay, this is talking about a 2-year green card, but I don't know whether because it says that the application has been filed since 2024 July. So at the time the application was filed, has there been divorce or was the divorce after the application was filed? I will answer both ways. If there has been divorce before the application for removal of condition was filed, so I assume that it was filed alone, maybe based on good faith marriage. But if it was filed initially as a joint removal of condition and then you divorce subsequently, yes, it will affect the application. But what you need to do is to write a letter to USCIS where the a petition is pending and attach a copy of the divorce document and then request them to adjudicate the petition based on good faith marriage. The law does not require that every marriage must work, but the law requires that every marriage must be entered into in good faith. That is, you enter into the marriage legitimately in good faith. You live together as husband and wife, but the marriage didn't work. That's not your fault. So you make that request, submit the divorce document, and submit a request that the petition be converted to self-petition based on good faith marriage. It should be this one.
Here, I think. Here, start
We're
right
gonna
there.
have to hurry because the questions are gonna start disappearing from the live chat.
Okay. Good day, sir. Is it advisable to file I-601A while here in the state? Does that protect from deportation despite being married to a citizen? If approved, does it automatically means visa will be applicable? Well, I-601A is for unlawful presence. It's only for people who enter the United States without a visa and they want to apply for green card. So whether you are in the United States or not, you cannot get green card in the US if you did not enter with a visa. So filing I-601A is to help you be able to come back if you do consular processing. So yes, you have to apply while you are still physically here, because if you step out before you apply, you will not be qualified for I-601A. You will need to first attend your visa interview, be denied, and then come back to apply for I-601. But if you are here in the United States, yes, you apply for I-601A, waiver of unlawful presence. And then before you can also apply for that, you must have approved I-130. You can't just approve for I-601A except you have I-130 approval. So you need to understand the process. If you enter without a visa and you are married to a US citizen, the first step is to file I-130. Once the I-130 is approved, then you apply for I-601A, unlawful presence waiver. Once it is approved, that is when you now go to the consulate. You go back to your home country and process your visa. It is that waiver, the approval of that I-601A, that will allow you to come back into the US. So that is that. I think we have to go into today's question.
Okay.
Is there any more that I'm yet to answer? Well, if there is any, they should send it today. Okay, today's questions. What I have here is different from what you
No, that's
have.
the first one.
That's the first one. Okay, let me just use that instead of my phone. Sir, how do I prove biological mother and daughter in Form I-130 because the birth of the child was registered 10 years after birth? Of course, you have to get evidence of the child, of your parent-child relationship when the child was a baby. School record, immunization record, baptismal record, all the things that you did as a child, maybe the child 1 year birth picture, photographs, even photograph from the naming ceremony, all the things that can show that you are the parent child of that child. If you are the type that travel early, maybe you have applied for travel passport for this child, they will list you as the parent. All the things that you did while the child was a baby But basically, immunization record, baptismal record, school records, preschool, elementary school, all those records, pictures, those are the ways to prove it. Next one.
Well, she sent a follow-up.
Okay. Sir, I'm chatting from United Kingdom and I have tried booking an appointment with your office for an urgent immigration matter, but to no avail. It's about for my 130 petition my daughter filed for me.
I think she was getting it very far.
Yeah, is there any? Can you move it? That's the.
That's it.
Okay, you can reach out to her to see if she can be accommodated.
And we don't have a way of reaching out.
They need to reach out
They need to reach out.
and explain
Maybe.
the situation to whoever they're speaking to.
So how do they reach out?
They can send a text to this number, and then we'll contact them from them.
Okay, what's the number? If
817.
if you are the one that send the questions, you can send a text to 817
891.
891 6655.
But it's going to be for this purpose.
For this purpose only, send a text to 817 891 6655.
And explain the situation in
And explain
detail.
that she's the one.
Please explain in your text that you are the one that sent this question so that they will attend to it appropriately. Okay, next question. The receipt notice indicated that Vermont Service Center, U.S. Citizenship and Immigration Services, 38 River Road, Essex Junction, Vermont, received the filing document. Do you know how long it will take them to grant approval of the Form I-130 petition? So I'm assuming this is a standalone petition.
There's more.
Okay. Can the I-130 be approved without submitting Form I-485 adjustment of status? Oh yes, that's what is called standalone petition. Can you please check the processing time for the service center? Is that a continuation?
She said my daughter had already.
Okay, my daughter had already submitted Form I-485 to USCIS for adjustment of status few days ago. Well, standalone application and adjustment of status, they are not the same. So if standalone I-130 are processed at the service center, which is why we wanted to check the processing time at the service centers. But if adjustment application has been submitted, that will change the narrative, because that will now send it to your local office. And right now, under this administration, if you file adjustment application, the processing time is about 6 months before they invite you for interview. So now that adjustment application has been submitted, so you are looking at an average of 6 months. But if it is a standalone I-130, the processing time is much longer, and those are processed at the service centers.
And I would need to know what the category is. I mean, is it a U.S. citizen filing for a spouse?
Yeah, it said my daughter, so I'm assuming this is parent-child relationship. Yeah, but like I said, the adjustment application will take it away from the service center, so it's going to go back to the local office for processing. And average time now for adjustment is about 6 months before they invite you for interview. Next question, please. I'm currently on F1 status. If I apply for NIWEB1, I-485, and I-765 concurrently, will I start accruing unlawful presence from the receipt date? No, you will not. You will be maintaining legal status once you have the receipt notice, for as long as the receipt notice was before the expiration of your I-94. No, you do not incur unlawful status. You are perfectly in status. However, if for any reason the I-485 is denied, from the date of the denial, you will begin to accrue unlawful presence, except you go back to F1 or you are still on F1. From that moment, you begin to accrue unlawful presence. But if it is approved, from the date you get the receipt notice, you are in status. You are not accruing unlawful presence. Next question, please. You and your team have been a huge blessing to me. Oh, thank you. I just submitted my adjustment of status package. I'm here to say what you are doing is priceless and well appreciated. More blessings to you all in Jesus' name. Amen. Amen. Thank you. Next one. Good afternoon to you and your team, sir. I have a 36-month extension letter on my 10-year green card. Does it mean that it will take 3 years to get my real green card? Thanks, sir. God bless you all. Well, we don't know what category this is. Is this removal of condition? If this is removal of condition, yes, it may take up to 3 years. They not necessarily 3 years, but at least they give extension for 3 years so as to give them enough time, especially now that they have started conducting site inspection, they have started conducting investigation and all of that. Yes, it may take up to that. But at the same time, we have seen application that was approved within 6 months, even removal of condition. It depends on the level of evidence that you have. So if you have overwhelming evidence, you can still get it approved within 6 months. But if this is the type that require investigation, yes, it may take up to 3 years. But usually, once you apply to remove condition, they give you extension for 3 years so that it will give them enough time to do whatever they need to do. And you also will continue to be able to use your green card, including traveling in and out of the country and working. So that is the reason they do that.
The current posted processing time is 26 months.
Okay, yeah, I've been told that the current processing time for removal of condition is 26 months. That is 2 years and 2 months. So, yes, that is the process. But like I said, we've seen applications that were approved within 6 months. Everything depends on how much evidence you have or you submitted along with your application for extension of your green card. Good afternoon, sir. Okay. Hello, sir. God bless you and your team for all you do, sir. Thank you. Amen. Sir, my question is, if Nigeria customary court divorce decree is acceptable, please. Oh, yes, customary court divorce is acceptable. However, let me clarify this. This is a very good question because we get this problem. We see people with this problem all the time. And I've said it on this program multiple times. There are 5 types of marriages recognized under Nigerian law. All the 5 types of marriages have their divorce decree. Number 1, marriage under the Act. If you get married by going to the registry in Nigeria, that is what is called marriage under the Act. For that, if you want to terminate that marriage, you have to go to court. That marriage can only be terminated by a decree nisi and a decree absolute. The court will first grant a decree nisi. Once they complete the hearing, they will grant a decree nisi. After 90 days, that decree nisi will become decree absolute. That is the only valid divorce document if your marriage was to the registry. On the other hand, if you got married under traditional marriage is what we call in Nigeria introduction and engagement. That is traditional marriage. So if you got married under traditional marriage, that marriage can only be terminated by the customary court. If you go to high court to get a decree, a decree nisi or decree absolute, that document will be invalid. If your marriage is customary marriage, you can only terminate that marriage by a customary court. So if you got married in a traditional way and you didn't go to the registry, it is the customary court that can grant divorce. And in such a situation, yes, your customary court document is valid for immigration purpose. But remember, customary court does not grant decree. This is where the issue is, because I've seen some divorce document that is purportedly issued by customary court and they are labeled decree nisi. No, customary court does not grant decree. Customary court will only grant a divorce document. So they don't grant decree. So if you get married the traditional way, it is the customary court divorce that you can use, and it is acceptable for immigration purpose. Now, there's another form of marriage in Nigeria called Nikai, which is Islamic marriage. If you get married under Nikai, so you have to follow the Islamic way of terminating the divorce. You have to follow the Islamic way of terminating the marriage. You cannot use customary court divorce for a Nikai marriage. You cannot use divorce decree for a Nikai marriage. It has to be document issued in accordance with Islamic law for that divorce. Now, if you get married in the church, which is another marriage that is recognized under Nigerian law, if you get married in the church, church marriage is associated with the court. High court of the state where you live is the one that can terminate that marriage. And the document you will submit as evidence of termination of that marriage, that one is called decree nisi, that will become absolute 90 days after. The last type of marriage recognized under Nigerian law is what we call common law marriage. Common law marriage. If two people, if two adults, if they start living together and they begin to represent themselves to people, to family, to friends, oh, meet my wife, oh, meet my husband, and people around believe that they are husband and wife, if they decide to end, that becomes a valid marriage. After living together in that kind of relationship for 6 months, it becomes a valid marriage. Now, if those type of people decide to terminate, to end that marriage, all they need to do is to do an affidavit of divorce. That is all they need to do. They need to go to the court and swear to an affidavit. I, Olu Askun, I was previously engaged in a marital relationship with ABC under a common law arrangement. We lived together from 1st of January 2023 until November 19, 2025. However, we have decided that we no longer want to remain as husband and wife. We have decided to part ways. I have decided to move away from the house. I am no longer married to ABC. So you do that affidavit. That affidavit is a valid document that is acceptable for the purpose of immigration. But you have to know the type of marriage that you enter into before you can determine what type of document will be acceptable for immigration purpose. So if your marriage is a registry marriage, you cannot use anything less than decree nisi and decree absolute. And if it is not, you have to know what type of marriage you entered into before you determine what type of divorce you will be required to produce, especially for immigration purpose here in the United States. Next question, please.
You asked him to check earlier about the processing time for that I-130, and you gave him the information?
No, I thought we already did that. We already told them, is that not the 2 years and 2 months?
He's saying that you promised to give it to him, but I don't think he heard.
But I don't know what type of
It's an I-130 the daughter filed for him.
the daughter.
So
Is the daughter a permanent?
The final
No.
one
I already answered that question because he said that the daughter eventually submitted I-485. That changed the dynamic. It is no longer a standalone petition. So question of processing time does not apply anymore. And I already said that since adjustment of status is involved now, we are looking at an average of about 6 months before they are invited for interview. I think I answered the questions.
Because this one was filed back in 2024, so I guess that's why he's wondering.
But she just filed the.
But according to that message,
said
the
that. They said
the
go on.
yeah, the daughter just sent the
Yes.
adjustment. It is the adjustment application that I'm talking about. Now that they have filed adjustment application, I'm sure they will be invited for interview even in less than 6 months.
Because
I'm sure
this,
he just heard you now because he sent that follow-up call. I mean, question, sorry.
Okay.
standalone is 17 months was the processing time then. So,
Since they have introduced adjustment of status, the dynamics is going to change. So, next question. I'm on H-1B status and my green card is being processed. Can I register my food business without the negative effect on my status or green card process? Can I also travel with H-1B? Thank you. Well, let me answer the first question, the last question first. Can you travel with H-1B? Yes, but is it advisable to travel with H-1B? No. If you already have I-485 pending, why not apply for parole? But if you still have a valid H-1B visa, yes, you can travel with it because H-1B is one of the only two non-immigrant visa that does not have immigrant intent. So the fact that you have I-485 pending does not invalidate your H-1B. You can still use it to travel. It is the exception to the rule. It's different. It is different from if you are applying for adjustment from B1, B2, or from F1, or from any other non-immigrant status. H-1B is a kind of non-immigrant visa with double intent. Yes, you can travel with it. But no, I think there's still another question. I started from the last one.
You're right.
So the first one was, can I register my food business? Well, there is no yes or no answer to this. It depends on a number of factors. Because recently, since this new administration came into play, I noticed that one of the changes, one of the policies that they are enforcing now is to ensure that every employment-based applicant or beneficiaries, they are complying with the conditions of their employment. So if you are on H-1B and you are working for a specific employer, mere registering of the business does not affect anything, but working for a business may negate your H-1B, may affect your H-1B. So you have to look at the condition of your H-1B. But mere registration does not affect you if it is just registration. But if you intend to run the company, you need to look at the terms of your H-1B, because that is something that USCIS under this new administration they've started looking into. If this were to be R1, the answer would have been absolute no. But this is not R1. This is secular employment. And like I said, H-1B has some flexibilities that most other non-immigrant visas do not have. Yes, you can register it, but whether you do business with the registration will depend on the terms and conditions of your H-1B. Next question, please. Good day, sir. Thank you for all you do. God bless you and your team. Amen.
Oh, we've taken care of that. He said that he wanted the volume a little louder, so we increased it.
Okay. Next one. Good morning, doctor. I was granted asylum in court, but I'm afraid to apply for travel document under this administration. Can I go ahead and apply? Can USCIS cancel my asylum? Thank you. No, they cannot. If you are granted asylum in court and the time to appeal has passed, if the time to appeal has not passed, I will tell you don't apply for anything. Wait. But if the time to appeal has passed, usually if you are granted asylum, the judge will ask both DHS and your own lawyer whether they want to accept the decision as final or whether they want to reserve appeal. Under this administration, they have been reserving appeal. So you have to wait and ensure that the appeal period is over. Usually, appeal period is 30 days. If the appeal period is already over, that is it. USCIS cannot revoke your asylum. They do not have that authority because USCIS is not part of the court. The court is under the Department of Justice. And if the court grants it, there is nothing USCIS can do. If USCIS deny it, they only refer you to court. But if the court grants it, USCIS does not have authority over the court. It is the other way around. The court have authority over USCIS, but USCIS does not have authority over the court. But remember, this is asylum. Also, you need to know what your story is. So you don't want to travel to the same country where you claim you are running away from. So those are the things you need to consider. But if it is granted by the court, USCIS cannot revoke it. They don't have such authority. Next question, please. Good afternoon, sir. I just got another private facie. What does that mean? Well, it means that your case is still being processed, but the prima facie document is one thing that allows you to apply for public benefit without any problem. If you need health care, if you are qualified for Obamacare or any benefit, it will not affect you in the process of your green card. So that is the advantage of the prima facie evidence. But it doesn't mean that your case has been approved. It simply means they are still working on it. But in the meantime, if you need any benefit from the government, this is an authority for you to apply for it without being affected. The next question. Thanks for all you do, sir. Sir, if the USCIS come on home visiting and they meet just one spouse, can one show them the US passport of the spouse that's not around even without asking for it? Well, showing them does not really do much, but it depends on the circumstances. It depends on the circumstances. If all you are trying to show is that you are living together, it is not the passport that will show it. But of course, the passport will also count because, if your spouse is not living with you, he or she will not keep his or her passport in that household. Yes, it will count. But more importantly, show them around. Let them see that you are living together. Let them see your living room, your bathroom. Let them see things that show them where you keep your things, where your spouse keep his or her own things. But yes, if you show it to them, that's additional evidence because passport is like money. Americans don't play with money. So they are not going to play with money, which is one of the reasons why immigration always asks for joint bank accounts, because they know that they will not play with their money. So if they have the guts to allow you to have access to their money, then the marriage must be real. So they know they don't play with money. So yes, passport will be close to that. There is no reason why somebody will allow you to have his or her passport if this is not a legitimate relationship. Yeah, you can show it to them, but more importantly, you need to have a lot of other evidence to show them around your house to let them know that you are living together as husband and wife. Okay, next one. How to prove to USCIS that the marriage certificate I presented is genuine? They requested for certificate should have seal. Is this a new question or the one I answered before?
No, this is a new question.
It's a new question. Okay. Well,
But he sent another question later. Okay, so how to prove to USCIS that the marriage certificate I presented is genuine? They requested for a certificate. Okay, the certificate must have a seal.
Yeah, this is
let me just answer. We'll go back to the other question because
I received it years back from Motion Marriage Registry. Okay.
Okay, I think I answered it before. I mean, just if USCIS requested for it, all you need to do is to go back to the issuing authority and request for certified true copy, and submit that to USCIS. That's it. That's the way to prove it. And of course, you can also prove your marriage with additional evidence of relationship. But more importantly, the marriage certificate, you request a certified true copy from the local government or from the issuing authority, depending on where you got it from. Okay, next question. Good afternoon, doctor and team. Please, good afternoon. Please, how long does a FOIA request take? Can you and your team be of help in requesting for FOIA? Well, it depends. FOIA from who? I mean, there are different agencies. You can apply for FOIA from USCIS. You can apply for FOIA from the court, EOIR. You can apply for FOIA from CBP. You can even apply for FOIA from the US Embassy. So it's a lot of FOIA has different scenario. Now, whether the timeline for FOIA also depends on a number of factors. Recent cases, recent immigration files, they are electronic. Electronic cases comes more quickly than paper cases. For example, if you have been in removal proceedings, if your case is electronic, what we call EROP, if we do FOIA, we will get it within 24 to 36 hours. On the other hand, if your case is a paper ROP, then ROP simply means record of proceedings. If your case is a paper ROP, then it will take several months because, I mean, you and I know that something that is electronic is a matter of downloading it. But something that is paper, they will still have to scan it. They will still have to do a lot of other things. But again, FOIA could also be from CBP.
Oh gosh.
That one takes forever.
Over a year.
CBP are known not to give priority to things like that. They take their time.
Department of State is
They
6
act
months.
as if they don't give a dime. They take forever. Yes, CBP could take over a year. That one takes a long time.
And then they always tell you that they can't find anything, so then you have to appeal it.
And most of the time, CBP FOIA, they will come back and not provide you what you are asking for. They will tell you they cannot find it. Most of the time, we will have to appeal before we can get them to release the information. But of course, they take their time. But USCIS will depend on whether this was electronic filing or paper filing. But either way, it's still much faster than Department of State. Good afternoon, sir. Please, what is the current priority date for special immigrant juvenile status? SIJ. Can you please check the SIJ? I know they have released the December bulletin. Okay, go to the next question while they are checking. Okay. Does that mean... Oh,
I apologize.
okay. Does that mean I'm close to an approval? I claim that in Jesus' name. This must be a follow-up to a question I answered before.
I don't see it.
Well, I will just say amen.
Okay.
This.
I just got another prima facie. What does that mean?
Oh.
She's the one that.
Oh, okay. The prima facie person. No. It doesn't mean approval, but it simply means that they are still working on your case, and you can use that document to apply for public benefit if you need to. But I still say amen to your question.
SIJ, that's the fourth
Yeah,
employment based
yeah,
salary,
that's
right?
what. But they list them separately from religious workers.
So it's September 1st, 2020.
2020. Okay, yeah, that question for SIJ, Special Immigrant Juvenile, the priority date is September 1st, 2020. That's the current priority date. Next question, please. Blessed week to you and your crew. Amen.
Amen.
I want to buy 128 booklet of civic study guide. No. They are not selling it. It's free of charge. Please don't pay anybody for it. It is completely free of charge.
I'll link it in the bio or in the description.
Okay, yeah, we will send a link to you. It's a matter of downloading it. Please don't pay anybody for it. Oh, it is free. It is free. You don't need to pay anybody.
We're not gonna send it, we're gonna post it
Yeah,
on the chat.
the link.
Yes.
Okay. Yeah, we will post the link on this chat so that you can have access to it. It is free. Please do not pay anyone for it. Sir, is it that the countries where people are being deported to are the countries being paid to receive the deportees? And what will the country then do with the deportees? Well, this is a new territory for all of us. We are learning this together. I mean, definitely, I'm sure that there is something in it for Ecuador. Why would they be accepting citizens of another country? There must be something in it for them. Looking at what the Trump administration has been doing with the different cities in the United States, they have been paying them in order to force them to cooperate with ICE. So it is possible that they may have offered financial incentive to Ecuador, but because I can't understand why Ecuador will agree to have citizens of another country deported to their own country. But of course, there must be something in it for them. Yes, money must have exchanged hand or been exchanged hand, or some other valuable things must have exchanged hand. They will not just sign an agreement without anything. Even in law, for any agreement, for any contract to be valid, there must be consideration. So consideration is something of value. So there must be a form of value to going to Ecuador for them to accept the citizens of another country. Yeah. Okay, next question. Is it true that those with EAD under special immigrant juvenile status will no longer be renewed or new ones issued? I think I say something about that last week. Was that last week? Or was it? I really can't remember that. Can you note that question? I'll come back to it. I will check because I don't want to mislead them. Can I get a pen, please? Let me note some. Yeah, I know that there was a recent issue with SIG about fraud or something. But I can't remember the issue. So I'll come back to that. But if you get the response, just let me know to that one. Okay, next one. Afternoon, sir. Is it true that people are being arrested during interview for visa overstay? Oh yes, that is completely true. Even people are being arrested even in their homes for visa overstay. Well, I don't know the prevalence of that, but I have seen clients who are arrested at home. I have in fact, I just did a bond last week. Was it Wednesday or when was it last week? Wednesday. I did a bond last week, and I remember, yes, I actually mentioned it live because I remember I had to leave early so that I can do that bond application. I remember somebody was posting a question and I apologized that I won't be able to wait to answer the question because I needed to go and move a bond application. Yes, this person was arrested at home for overstay. Nothing. No, he doesn't have any application pending. He didn't have anything that was denied. He was just in his house, and ICE officers knock upon his door around 5:30 a.m. and they told him that he needed to do some fingerprinting. So his wife asked them, can she follow them? And they said yes. So all of them went to ICE office. So later they told the wife to go, that they are not done with him. And from there, he had to call his wife that he has now been detained. So yes, can they be arrested during interview? Yes, but not in all cases. Not in all cases. Usually, why would you even go for interview if you don't have something pending? So if you overstay and you have already applied for something, so that means you already have an application. So if you attend an interview, that is not the kind of scenario where you will be arrested. But if you have criminal record, or if you have a prior removal order, because this is where a lot of people confuse the issue. If you have a prior removal order and you didn't do anything about it, and you now married a US citizen who filed a petition on your behalf, and you attend an interview, yes, I can tell you the probability that you will be arrested is 100% if you have a prior removal order. But if all you did was to overstay, and then you file an application, and then you are invited for interview, no, you will not be arrested during the interview, because the application that you file that is pending, for which you are invited for interview, at that moment, that application keeps you in status. So they cannot arrest you, except there are other underlying factors. Maybe you have a warrant of arrest. Maybe you have criminal record. Maybe you have a prior removal order. Those are the circumstances that can lead, or you entered EWE in the last 2 years. Those are the circumstances that can lead to your arrest, or you have engaged in a theft offense. All those things that come under mandatory detention, those are the kind of things that can lead to arrest. But mere overstay with a pending application does not lead to arrest. Next question. If I'm on F1 status and my spouse is a green card holder, files I-485 for me, will I start accruing unlawful presence? No. However, for a green card holder to file I-485 for you, it means that visa must be current, because remember, green card holders do not enjoy the same benefit as US citizens. US citizen can file for any immediate family member at any time. There is no issue of visa availability. But with a green card holder, visa must be available. So if you have been maintaining status and you are still on student status, valid F1 status, and your green card holder spouse file I-485 on your behalf, if that I-485 was accepted for processing, no, you do not accrue unlawful presence status. You do not. Next question. I had I-129 interview last year in Nigeria, which was denied. We were asked to change our case to I-130. No, that cannot be I-129. Maybe he's talking about I-1 fiancé visa, I-129F. Yeah, that must be, yeah.
That makes sense.
Yeah, many of these people try to use terminology. They don't know that there are little changes. Yeah, because I-129, that's a non-immigrant visa. Yeah, that's but that is probably talking about a fiancé visa. That's 129F. Yeah, okay. Yeah, I had I-129F interview last year in Nigeria, which was denied. We were asked to change our case to I-130. I currently reside in the UK. What steps can we take to move the interview to where I live now? That's very easy. The only condition is that in the UK, you must have a valid status, not visiting. If your status in the UK is visiting, no, they will not approve it. If your status in the UK is something that is legal for less than a year at the time of interview, you will not be able to transfer it to the UK. But for now, I don't know the status of your case, whether the I-130 is still pending or is been approved or has even been filed. If it has been filed, all you need to do upon approval, they will notify the National Visa Center. That is where you will submit immigrant visa application. Then that is why you will notify the National Visa Center that you now want to process your case in the UK. But please, before you do it, you have to verify that you have legal status in the UK, because otherwise you may end up prolonging your case. Because if you make the request, they will ask for proof of your legal status in the UK. And if it is not something that is acceptable, then they will deny the request. So that will further delay your case. But if you have a legal status in the UK, like a UK permanent resident, or is it indefinite leave they call it in the UK, if you have something like that, or if you have a student visa that is valid at least for 1 year, or as at the time of the interview, then they will accept to process it in the UK. But all you need to do is to wait until the case gets to the National Visa Center, and you notify the National Visa Center that you want your case processed in the UK. But if you are yet to file the I-130, you just indicate in the application itself, in the petition itself, there's a question there that says for you to select the consulate. Indicate the consulate where you want your case processed. Then you should select the UK. But if it is already pending, then contact the National Visa Center after the case is approved. After the I-130 is approved, then notify them that you want your case processed in the UK. Next question, please. Good afternoon. My wife is here on, is this L or? Okay, foreign media. I didn't see that one before. Okay. My wife is here on I visa, foreign media representative. I'm a US citizen and in the military. How do I file adjustment of status for her? I visa, can you confirm if they can adjust? I'm not 100% sure. Yeah, confirm if they can adjust. But if they can adjust, you just need to file I-130 and I-485 concurrently for her, since you are in the US military. But let me just confirm if they can adjust. I don't think they are within the category of people who cannot, but I just want to be 100% sure. I know that J visa cannot, except they obtain a waiver.
So it says they're eligible for family-based, employment-based, or VAWA, for as long as they
Oh,
do not violate the status, entered lawfully, and have no bars to adjustment, like certain immigration violations or inadmissibility issues.
Well, that's not, yeah.
That's for journalists only.
Yeah, I know. Yeah, I just want to know that the foreign residency thing does not affect them. Yeah, it does not. Okay, so to go back to your question, since your wife is here, you are a U.S. citizen and you are in the military, just go to USCIS website, or you can go through our own website. You will see a button that says check the status of your case, or what does that button say again? There's a button where you see immigration forms. So you click on it, it will take you to the page where you can download the forms. So download Form I-130, Form I-485, Form I-765, Form I-864, I-130A. So fill up all of these things. And of course, if you want your wife to travel while the case is pending, you also do I-131. So fill up all this form, attach the filing fee, mail it to immigration with all the necessary documentation, evidence of your marriage, marriage certificate, evidence of commingling of assets, evidence of your wife's legal entry. Your wife needs to do medical examination. There is no waiver for that. It doesn't matter whether you're in the military or not. Everyone must conduct medical examination. So attach 2 passport photographs each for you, for your wife. Attach the fees. Immigration no longer accept checks or money order or anything like that. Fees can only be made electronically. So you can attach credit card information and then mail it to USCIS. That's it. That's the procedure. That's how to get it for your wife.
Credit card information through the form, not just attached.
Yeah. There's a form. What's that form number?
G1450.
Yeah, G1450. That you can use that for credit card information because they will not accept cash or check or money order. Hello, doctor. Do medical report expire? Yes. I have submitted my medical examination report since 2022. Until now, I have not had any information from USCIS. I'm a religious worker. Yes, it does expire, but you don't need to do anything since you have submitted it before. So if USCIS want you to update it, they will send you a letter asking for it. If they don't ask for it, don't do it. So just leave it. But does it expire? Yes, it does expire, but it depends on immigration because they keep changing the policy from time to time. There was a time they had a policy that it will expire every year. At some point, they changed the policy that it will go to 3 years. At a point, they changed the policy that once you submit it, they will allow it to be valid until the process is complete. So they keep changing the policy. So I currently don't even know what their policy is right now. So the best thing is, since you have submitted it, you have played your part. If they believe that it's expired, they want you to do a new one, they will send a letter asking you to provide an updated one. But does it expire? Yes, it does. Next one. Doctor, can I travel for 15 days with advance parole to my home country 3 years down the line? I hope this is not the person, the asylum question guy.
Let me see if they asked any other question before.
Yeah, if it is, somebody asked a question before whether you can apply for advance parole, whether I can apply for travel document after being granted asylum, was asking if USCIS can still revoke the asylum. I said no. If it is not that person, then I don't know how to answer this question because it's not connected with anything. It's a standalone question. Can I travel for 15 days with advance parole to my home country 3 years down the line? So what is your current status? What are I don't know. I mean, this is an isolated question that I don't have the underlying facts. So I don't know the basis. There must be a basis for the fear or for the question. I don't know that. Next question. If the person who asked the question is online, you can quickly clarify it because at least today we have been here for more than 1 hour already, but I want to try as much as possible to answer as many questions as possible. So if you are still online, you can clarify it. So what do you have pending? What is the basis of the advance parole? Is it a family-based petition? Then why the issue of 3 years down the lane? I really don't know the underlying factor, so it's difficult to answer the question. Next one. I have a pending asylum case and my EB2 NIW is current. I came to US through F1 and was in status when I filed the asylum. What is the probability of getting my case approved? But it still does not even have an approval for the EB. Because, my EB2 NIW is current. The probability of getting EB2 approved has nothing to do with your legal status. It has nothing to do with it. It's basically dependent on the eligibility criteria, which is, of course, you have to meet 3 out of the Part A eligibility categories. You have to meet 3 of them. Then the B categories, you have to explain why the government should waive the requirement of labor certification or job offer. So you have to show what is it that you are bringing to the table that an average American does not have. An average American with the same qualification as you. That it is the eligibility issue that determines whether you are approved or not. It is not your status. If you are approved, then whether you are eligible to adjust status will depends on the timeline of your asylum application. And since you are from this information, since you are maintaining legal status as at the time the asylum was filed, then you will probably may be able to adjust status. I'm using the word may because you see, the fact that you are on F1 as at the time that you apply for asylum does not make your asylum approvable, because there is still this issue, this challenge of 1 year, 1 year timeline, which is statutory. So if you have been here, even if you are legal on F1 status, but you have been here for more than 1 year, you may still not be able to get your asylum approved. So there are a lot of things that we have to understand with the way immigration law works. Yes, you may be maintaining legal status, but as at the time, if you have been here for more than 1 year, then that may not even make your asylum approvable. So that's why I use the word may. Next question. If child is filing adjustment of status for parent, should both applications be done at the same time or one at a time? Well, it depends on the child's capacity, because since this is a family-based petition, it will require affidavit of support. So if the child's affidavit of support can carry both of them, you can file for them at the same time. Even if it cannot carry both of them, you can use a joint sponsor for one of them while you carry one. But again, what determines whether you do it one by one or you do it concurrently is your pocket. Remember, these things cost money. So if you can financially afford it, yes, why not? You can do it together. There is no law that says you have to wait for one to, no. If you have the means, if you have the financial means, yes, you can do it together. Because if you don't do it together, imagine if one of them have green card and the other is put in removal proceedings for overstaying. How will you feel? So if you can afford it, it's better to do it together. Okay, next question. NVC scheduled interview for my husband in January 2026. Can he go with our daughter who is under 21? I filed for my daughter in August 2025. No, but what you can do, request expedited processing of your daughter's I-130. In fact, this is one of the areas where congressional intervention may be useful. I mean, if you can get the I-130 expedited, yes, they may still be able to add it, but right now, the way it is based on this fact, no. They will not even allow your daughter to go in with your husband on the day of the interview. They cannot be processed together. This is one advantage that green card holders have, but U.S. citizen does not. If you are a green card holder, yes, that petition that you file for your husband will have covered your daughter. But because you are a U.S. citizen, it does not cover your daughter. You have to do a separate petition for your daughter. And since you just filed that in 2025, the only thing you can do is to request expedited processing. Seek congressional intervention. Let them know that your husband is already going to the embassy for interview in January, and you want your daughter to be able to come with him, because if he is approved and he comes here, there will be nobody to take care of your daughter. So use that as a reason for requesting expedited process. But more importantly, go through congressional intervention. That will be helpful. Next question. I'm a LPR who filed for my daughter who is under 21. Okay, what's the question?
I know I saw it here. I'm coming. I don't know where it is. Oh, okay, that's the same person that you just responded to. The NVC one. This is it. See, that's the same person. The one that the husband was scheduled for January. And then she's like, I'm an LPR who filed for my daughter under 21.
Oh, it's the same
She's
person.
an LPR.
Oh, okay. Well, good thing I already answered the question, because I explained that if the daughter was under 21 and you are an LPR, then the MVC should have added your daughter to your husband's case. So it shouldn't even be an issue of going to the embassy alone. The MVC should have added your daughter.
But she
If
just filed. Why did
She
she
doesn't
file
need a
already?
separate petition. You don't need a separate petition for your daughter. The one you file for your husband, your daughter should have been included.
Yeah.
So you need to contact the National Visa Center to let them know that they missed out your daughter, or maybe there is something here. You know that I assume a lot. Maybe the husband is not the biological father.
Oh, it could be.
Yeah, maybe the husband is not. If your husband is the biological father, you don't need a separate petition for your daughter. The one that you file for your husband, the one that he was scheduled to attend interview in January, your daughter should be included. If your daughter is not already included, then you need to contact the National Visa Center immediately that something is missing, that your daughter was missing because when they send you the invoice, they ask you to pay the immigrant visa fee. They will have included your daughter. If they didn't include your daughter, that is the time to correct them. But it is not too late because the interview is still in January. Contact the National Visa Center immediately. That is assuming that your husband is the biological father of the child. You don't need a separate petition at all. But if your husband is not the biological father, then you need a separate petition, and that is going to be processed separately.
He posted the question 3 times, this person,
Oh, okay.
and you already addressed it.
Okay, next question. If someone has a pending asylum in the US, filed after 1 year, and now wants to apply for an immigrant pathway in Canada or UK, do they need to return to Vietnam first or apply directly from the US? Well, this is a question I don't know the answer to, because, to be honest with you, I don't know how immigrant pathway works in the UK or Canada. I don't know. But one thing I will tell you is, if you have a pending asylum here in the US, it doesn't matter whether you file it within 1 year or after 1 year. If you have a valid employment authorization, with that, you can apply for Canadian visa. That I know. You can apply for Canadian visa. But how do you now get immigrant pathway in Canada? Unfortunately, that I don't know. How do you get immigrant pathway in the UK? I don't know that. But I do know that if you have a valid employment authorization that is based on a pending asylum application, you can use that to apply for Canadian visa. That much I know. Now, the next question. Good day, sir. Please, I filed I-130 for my children under 18 years old in January this year. I'm a green card holder. When am I expected to receive the approval and other action? Well, this person didn't indicate whether these children are here in the US or they are outside the US because the procedure is different and the requirements are different. If they are here in the US, whether you will be able to apply for green card for them will depend on whether they are maintaining legal status and visa is current. If they are outside the US, then you are still going to need 3 additional steps in addition to the I-130 that you file for your children. Because for people who are outside, that is a 4-stage process. Stage 1 is the I-130. Upon the approval, they will forward the approval to the National Visa Center. That will be stage 2. That is where you will pay immigrant visa fee. That is where you will submit affidavit of support. That is where you will submit immigrant visa application. Huh?
You just sent the message that they're outside the US.
Okay, yeah, that's what I'm explaining right now. So, because they are outside the US, that's a 4-stage process. So, what you are doing right now is just stage 1, which is the I-130 with USCIS. Once the I-130 is approved, they will send the approval to the National Visa Center. So, the National Visa Center will contact you and ask you to pay the immigrant visa fee. They will issue an invoice for your children. So, you will pay the immigrant visa fee. You will submit immigrant visa application. You will submit affidavit of support. You will now, your children will have to obtain police clearance certificate. Remember, until recently, children under 14 do not need police clearance, but now they have removed the presumption of good moral character for children. So every child now need police clearance certificate. So you will collect all of that and submit it with the National Visa Center. Once the National Visa Center finish processing, they will schedule an appointment for them at the US Embassy, and that will start stage 3. So at that stage, they will have to contact the embassy and go for medical examination. So all of them will attend medical examination, and the clinic given to you by the embassy will send the report directly to the embassy, and then they will attend their interview. If they give them immigrant visa interview, that will end stage 3, and now you will need to come back to USCIS where you started to pay what is called green card processing fee. Because if you don't pay that fee, they are not going to get green card until you pay it. That's when they will get green card. So it's still a long process because they are out of the country. Next question, please. How old can a child be to file for from American spouse? Yeah, the question is, in order for an American spouse to file for their stepchildren, so how old would that be? Okay, number 1, the marriage that created the stepchild relationship, that marriage must occur before the children turn 18. If they are already 18, your American spouse cannot petition for them. That's the law. It's not a discretionary thing. But at the time of your marriage, those children must be under 18. So if they are under 18, then your wife, your American spouse, can petition for them anytime before they turn 21. Yeah, that's it. Next question. Good afternoon, sir. Thank you for all you do. God bless your team. Amen.
Amen.
Sir, what is the processing time for VAWA? I've applied since 2021. I have 5 years work authorization and travel document. And what steps should I take, sir? Can you please check the processing time for VAWA?
Almost 4 years.
Yeah, let me just confirm. Go to the next question while you are checking, so as to save time.
Okay, he didn't complete his question here, but he just sent it. So he sent a new one here, which is the same one, but more complete.
This one? Okay. I'm a US citizen and filed for my wife, and kids here in Houston since February 2024. NBC has rescheduled and canceled our interview 5 times already, and no other updates since May 2025. What can I do? Well, I will suggest that you do congressional intervention. Go to the congressman in your district, especially if your congressman or congresswoman is a Republican. Tell them exactly what you just told me now, and then they will ask you to fill a form to grant them authorization, and then they can make congressional inquiry with USCIS. USCIS. I'm right. Yeah. Okay. Did you
44.
get?
44.
Okay. For processing time for VAWA, I understand it is currently 44 months. That's how many years? 4 years. Almost 4 years.
3
But
years and 4 months.
2021 too is almost 4 years.
4 months.
3 years and 4 months. 8 months, sorry.
Yeah, but if I recollect that question, it said 2021.
21, yeah.
22, 23, 24, 25. That's already 4 years. So it's already outside processing time.
No, 4 years.
Yeah, it's already outside processing time. If the processing time is 3 years and some months, this is
No,
already.
when you're checking the processing time,
Mhm.
they ask you to put the priority date down there and see if you're now eligible to submit a service request.
But it's VAWA, they can't do a service
You
request
can't do
unless they have
you
a
can't do a
VAWA.
service request for VAWA.
You're so
Unless you have
right,
an
yeah.
attorney.
Yeah, it's what I will suggest again. Try congressional intervention. I mean, it doesn't hurt.
Or if they have
Even though for VAWA, I'm not even sure if congressional intervention can work for VAWA. I don't think so. I don't think so.
if they have an attorney, the attorney can send a request via
Yeah, well, contact your attorney. We still have 1 or 2 ways of contacting them without, because VAWA is treated differently. So a congressman may not even be able to do anything about VAWA because they are treated with utmost confidentiality. So if you have an attorney, contact your attorney to make some inquiry on your behalf. Next question, please.
That's the one.
Okay. Hello, I have a question. Thank you so much, sir, for everything that you do. My question is, I was scheduled for a deportation proceedings, but my court date was postponed. I also have a VAWA case. Is there a follow-up? Okay, I also have a VAWA case in process. Is there any advice on how to move things forward, or do I have to wait until the next court date? Additionally, I don't have a work permit. Well, I don't know if you file the VAWA yourself or if you use a lawyer. I don't know if you file adjustment application I-485 along with your VAWA, because without I-485, you cannot get employment authorization. That's the bottom line. There is no way you can get employment authorization without I-485. I-485 is the adjustment application. Employment authorization and travel document, they are associated, they are attached to a pending I-485. So if there is no I-485, there is no way to get employment authorization. So if you are going to get employment authorization, the first thing you need to do, submit an application for adjustment of status to the VAWA office. They will issue a receipt notice. And then with that receipt notice, you can now submit an application for employment authorization. But I still want to say something about the court proceedings. Yes?
It's not to the VAWA Service Center. If you're in removal proceedings, you have to send the I-485 to the Texas Service Center. You have to, no matter what the relief is.
No, I was even talking. Oh, okay.
Yes.
No, okay. I got you. Okay. Yeah. I've been corrected here that the the adjustment application has to be filed with the service center, not the VAWA office, because you are in removal proceedings. So because you are currently in removal proceedings, you have to submit the adjustment application to the service center. Now, that is dealing with the issue of employment authorization. But the issue of the court date, because the question is, what can I do to fast track my case? I want to advise you, please do not fast track your case because your VAWA has not even been approved. You need to understand, court and USCIS are not the same thing. Their processes are completely different. If you have a pending case and you go to court, depending on who the judge is, especially under this administration, the judge can tell you that they cannot wait for the VAWA to be adjudicated. It's a possibility. So in some cases, some judges will tell you to file your VAWA in court by filing what is called special rule cancellation of removal. But I want to tell you today, based on experience, special rule cancellation of removal and VAWA with USCIS, they are far apart. They are not the same thing. They don't get the same result. If you file VAWA with USCIS and you have a 80% chance of getting approved, if you file the same exact VAWA in court under special rule cancellation, your chances of getting approved will reduce to 40% from 80%. Why? Because of several factors. Number one, USCIS VAWA officers, they are specially trained on how to identify abuse. They know what constitutes abuse. They know when certain people have been abused and yet they are not willing to talk. They know what to look for to identify people that have suffered extreme cruelty. Immigration judges are not trained in this area. They are going to be using common sense to look at your case. Number two, when you submit a VAWA at VAWA office, you are dealing with only the USCIS office or officer. If they have questions, they will issue a request for evidence and give you time to respond. But when you are in court, you have a lawyer that is representing the DHS who is going to be antagonizing you, who is going to be telling the judge why the case should be denied, who is going to be looking for errors in your case. Remember, these are people who are not trained about VAWA. They are not trained about abuse. They are using their common sense. They don't know how to identify psychological torture. They don't know how to identify psychological trauma. They are using common sense. Oh, okay, if this person is doing this, why didn't you leave? Why didn't you just leave? Why didn't you just leave him? Why? You keep wondering. Abusive spouses, most of the time, they find it difficult to leave the person who is abusing them. They find it difficult to leave the perpetrators. This is because people who are abusive, they have these special skills that when they abuse you, they kind of make you feel that, oh, it's your fault. Oh, I'm sorry, I wouldn't have done that. If not, you know that it's your fault. You are the one that got me angry. You are the reason I did this. Yeah. But those VAWA officers are trained to identify all these things. The lawyer who is going to be arguing against you is not trained to understand all these things. And is going to be using common sense. The judge is going to be using common sense. And you are going to be facing a lot of issues that will ordinarily not come up when USCIS adjudicates your case. So you better leave your case with USCIS. Let the court process follow its own path. That will be my recommendation and that will be my advice to you. Next question, please. Good afternoon, sir, and thanks for giving back with your team. Thank you, too. Please, sir, I went for my marriage-based USCIS interview with my wife, and the interview went well, not until the officer said his system is showing I left since May 20th, 2016, in which I came into US in April 2016. If I request for FOIA, will I have to send it to USCIS? No, you don't need to send FOIA to USCIS. It is USCIS that we... FOIA means that you are asking for copies of what they have in their own file. So if you know that you are here, you didn't leave as they allege that you left in May 2016, they will correct their system. They will find out, because they will investigate it and they will find out. I'm sure you have a copy of your visa. You have a copy of your I-94. So they may have mixed things up. Maybe this was before they started using the electronic I-94. Even with when they started the electronic I-94, there was still a lot of errors at the initial stages. So they will figure it out. So you don't need to send them any FOIA, because when you do a FOIA, you are asking for copies of what they have in their own record. So it is what they have. It is whatever the officer is looking at that they will send to you. But if you know you didn't depart as they claim, just stand your ground, and they will investigate it and come to realize that they were wrong. Next question. Thank you, sir, for all your effort for we the immigrant community.
You already responded to his question.
Oh, okay.
Yeah.
Thank you. Okay. Does the 1 year asylum filing affect a minor who came as a child but asylum denied and was sent to immigration court? She's 18 years old now but came in when she was 10. Well, it applies to everybody, but it can be used as extraordinary circumstances justifying the late filing. That can be explained in court. You can use that. Well, I was a minor. I didn't even know that I needed to file anything. I was brought here by somebody else. And yes, it can be used to justify the late filing. But does it affect minor? Yes, it affects everybody. But there is an exception for changed circumstances or extraordinary reason for not filing within the 1 year deadline. So it can be useful. Okay, B part of the question. Her asylum was filed after a year she entered USA with visa. She was 10 years at that time, but now she's 18, still waiting for the court proceedings. Yes, I already answered it. The fact that she was a minor would be useful in proving that, in fact, by law, she was supposed to show that she acted immediately she turned 18. She acted on time. But because the asylum has already been filed before she even turned 18, that will also be to her credit. But yes, it's a valuable information that will be useful. Next question. Hello, sir. As a U.S. citizen, can I file for my brother who is an F1 student on OPT? OPT has not been approved yet. He plans to go to nursing school to get employment green card as a backup. Yes and no. Yes, because as a U.S. citizen, you can petition for your siblings. But no, because your petition cannot keep your brother in legal status. Because right now, for siblings of a U.S. citizen, the waiting time for visa to become current is about 16 and a half years. 16 and a half years. So while waiting, after you file your petition cannot keep your brother in legal status. Your petition cannot serve as evidence of legal status. Your petition cannot give your brother employment authorization. Your petition will just be there until visa becomes available, which may take 16 and a half years. So that's why I said no, your petition is not going to help her. But if she's on OPT right now, all she needs to do is to keep herself in status, maybe go back to school, go back to nursing school, so that she will be on F1, and then upon graduation as a nurse, then she can always get employment-based green card, because nurses are not required to go through the process of labor certification. So that's it. But your petition cannot keep her in status or keep him in status. Okay, very true, sir. Yes, customary court. Oh, okay. That one was probably reacting to my previous response. Thank you.
Also, you already responded to that. He wanted the processing time of the I-130, but then later you found out that they actually filed the I-485.
Okay, okay.
Yeah.
Good afternoon. My mom filed the I-130 1 year in this month, F3 category. Is this time frame okay, or is it taking long? So I'm assuming that the mom petitioned for her. So F3 is unmarried. No, married. F3 is married. F1 is unmarried.
Yes.
Yeah. F2 is permanent resident. F3 is married. Yeah. So this is married child. Yeah. So good afternoon. My mom filed the I-130 1 year in this month, F3 category. Is this time frame okay, or is it taking long? Can you please check the processing time for F3? I know that the last time I checked was about 9 months,
Is that
9
on the
years.
Visa bulletin or on?
Yes, visa
Okay.
bulletin, yeah.
They are currently working on September 8th, 2011.
2011, this is 2025. That's about 14 years.
14 years.
Yeah, so the processing time for F3 is now 14 years. That is married children of U.S. citizens. Yeah, that category takes time, yeah. It's only, the only one that is longer is sibling.
Yeah.
Okay, next question. Nigerian family seeking U.S. relocation. Accountant, 27 years experience. Wife, MED, educational management and public health. Teaching secondary school. What legal U.S. work immigration path exists? These are not the kind of question we answer on this podcast, because this is an open-ended question. It's not. My advice to you, whoever sent that question, take your time. This podcasting, we have been doing it forever. We have been doing it for years. Go back to some of our old videos. I know that in the past, we have done podcasts on how to obtain legal permanent resident in the United States. We have done podcasts on employment-based petitions in the United States. We have done podcasts on different categories. EB, we have done podcasts on EB1, podcast on EB2, podcast on EB3, podcast on EB4, podcast on EB5. And we have also done some podcasts on specifically on what you can do to get legal status in the US. So if you go back to some of those individually titled podcasts, then you can get a lot of information. But this is an open-ended question that we cannot deal with in this type of time frame podcast. We've been on now for 1 hour 45 minutes, and we have to stop it by the time we get to 2 hours. Not.
Oh, we even maybe a little bit before, because you have that detention center.
Oh. Thank God for reminding me. Yeah, we have to stop it probably in the next 5 minutes. We've been on for 1 hour 45 minutes, and they just reminded me of my appointment now with a detention center facility. So we need to end this in another 5 minutes. So let's
the
see.
lady asking about the F3 category,
Uh-huh.
she said that it's at the National Visa Center now for 1 year.
Yeah, she need to look at the priority date. Just go back and look at your priority date. So because National Visa Center is not going to contact you until visa becomes available. So that's what you look at. We told you the processing time, but check your priority date. And I think the priority date here says they are processing January 2011. Oh, September 2011. So check your priority date. That will give you an idea. Okay, next question. Sir, if I filed for VAWA since 2020 and I've been given I-485 twice and it's still valid, what is I-485? That's a,
765.
maybe employment. Yeah, okay.
Yeah.
I'm going to read it correctly. I've been given I-765 twice and it's still valid till June 2026. But I checked my status is showing pending. So what can I do? I have not been called. Well, I think we answered this question before. This is one of those things that is difficult to contact USCIS because of the privacy concern. I explained that congressional intervention may not work in this case. So if you have a lawyer, contact your lawyer to find a way. We still have a couple of back doors, back ways that we communicate with USCIS on VAWA cases. Because this is not one of those cases where you can do service request. VAWA cases are not available for all that. But if you have a lawyer, tell your lawyer to contact USCIS on your behalf that this case has been pending since 2020. Did you check the processing time for
44
VAWA?
months.
44 months. So definitely
Yeah, it's over
VAWA
4
that's
months,
been
yeah.
pending since 2020 is outside the processing time. So tell your lawyer to contact USCIS on your behalf. Next question. Good day, sir. Thank you for all you do. Can someone on R1 study something else like nursing while still on R1 status? 2, can someone who registered for Medicare but never used it still get a green card? Well, the first question, if you are going to go to nursing school, if you want to study nursing, you will need to do a change of status from R1 to F1. You cannot go to nursing school while on R1. I just said it a few minutes ago that R1 has a peculiar requirement solely, SOLELY, solely. You cannot do anything else. Whatever you tell immigration you are going to do for the religious organization, that is the only thing you can do. You cannot do anything else. You cannot go to school. However, if you have dependent, if you are married and your spouse is on R2, incidentally, your spouse can go to school without changing to F1, but you cannot. But your spouse can go to school. Next question. Good day, sir. Thanks for everything. God bless you and your team. Amen. I appreciate discussions with you last week. Sir, if I'm waiting out this period before applying for anything, can my son, who will be older than 18, still benefit from my follow to join from my LPR? Yes, the cutoff for follow to join is 21. So if your son is 18, yes, you can still benefit. The cutoff is 21. When your son turns 21, that's when he will be treated as an extended family member. But until then, you can still benefit. Next question. Sir, based on the common marriage you just mentioned, maybe common law. Common law marriage you just mentioned. If the couple are still together, then they are not separated since they have been living together. What type of document can be used to prove? You want to move it up? To prove their spousal relationship. Of course, they can prove their spousal relationship with evidence of commingling of assets. Evidence of commingling of assets, just like any other relationship. Joint lease, joint bank accounts, utility bills, joint insurance, health insurance, life insurance, auto insurance, renters insurance, trips together, you travel together, the ticket, the boarding pass, the take pictures in the plane. everything that a normal husband and wife who live together can use to prove relationship. If they have children together, birth certificate of the children, yes, they can use a lot of all those things to prove evidence of their relationship. Next question. Please monitor the time so that I don't miss my appointment with the detention center. Good afternoon, sir. Can someone travel to Nigeria with an expired Nigerian passport? Oh, yes, you can do that. You can do that. I'm 100% sure. If you are a Nigerian citizen, yes, you can do it. I'm 100% certain.
Take you?
What?
The airplane will take you? The airline?
Yeah. 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 If you are a Nigerian and you are traveling directly to Nigeria, yes, you can do it. I've done that 1,001 times. In fact, I did that as recently as this year with my daughter.
You can?
Yeah. Yeah, I traveled to Nigeria this year, June, with my daughter with expired Nigerian passport. For as long as you are going directly to Nigeria, not that you are flying from here to Europe. If you fly Delta, you fly from Atlanta straight to Lagos. Yes, you can fly with expired passport. That I'm 100% sure. I've done it 1 million times. And I still did it as recently as June of this year. Next question. I think we should be rounding up now. I see 142, 153.
Four-part question, so I don't know if you wanna.
Just 4 more.
Question.
Oh, 4-part.
Yeah.
Well, that's going to be the last question for the day because I have to, like I said, no matter how long this podcast takes, we can't answer every question. Okay. Good day, sir. I enter US on B1, B2 before I-94 expire. I apply for asylum. Since then, my case has been pending at immigration court. Is that part of it?
No, this one here.
It's not flowing.
This one.
Okay, it's repeating it.
Yes.
Okay. Good day. I have a question regarding the adjustment of status process. I thought I was reading something about asylum.
It's the same person.
Okay. Go up a little. I see 2 of 2. Maybe.
Oh, you know what? The other one, he retracted it. It's still showing on here, but it's not.
Let's move fast. I've just 1 minute.
This is it. The one on
Okay.
the screen.
Okay. Good day, sir. I have a question regarding the adjustment of status process in relation to my case in immigration court. I entered the US on a B2 visa and applied for asylum before my I-94 expired. My I-140 petition has been approved and my priority date is current. However, I've been waiting for over 6 months to receive a response from the immigration judge. Can I terminate my asylum case and can I then proceed with my adjustment of status from outside the US? Additionally, can I contact the National Visa Center to schedule an interview in a third country? Lastly, am I required to apply for I-601A waiver considering the possibility that I may face a re-entry bar if I depart the US? Well, this is a long question. First and foremost, the probability that the immigration court is going to terminate your case is very, very low. I'm not going to use the word impossibility, but it's very, very low because under the current administration, they are not terminating cases right now. Secondly, if you apply for asylum before the expiration of your I-94 and you now have an approved I-140, you may still be eligible for adjustment of status, even at the immigration court. Thirdly, if you want to do consular processing, if you ask the court, well, like I said, the probability that the court is going to terminate your case is not going to happen. Well, the probability is extremely low. The best that the court can give you, the court can probably grant you, what is it called? Voluntary departure. The court can grant you voluntary departure. But let me tell you, by the time you depart to come back is going to be problematic, because whatever is keeping you here right now as you being here lawfully, that one will be eliminated. And because you have been here for more than 1 year after the expiration of your I-94, you are going to face the 10-year bar. And now you cannot, if you leave with voluntary departure, the maximum allowable by law under the United States immigration law for voluntary departure is 120 days. 120 days, 4 months. That is the maximum. So assuming that the judge is generous and decided to give you the maximum amount of time, they can only give you 120 days, which is 4 months. Probability that you are going to get I-601A approved in 120 days is very low. So all these things, if I'm in your shoes, I would rather pursue adjustment of status based on the fact that you are lawfully present in the United States, because as at the time you file your application for asylum, you are still maintaining legal status. That would be my advice. And if you still have I have an appointment in 2 minutes with you.
The cutoff question.
Oh, perfect.
Okay, so, well, we are going to have to end this today at this time. We hope to see you again next week. Hopefully next week I will have time to stay up to 2 hours as we did today, because I'm looking at the time now. This is 1:59. We've been here for 2 hours. So we hope to see you again next week. Until then, remember to follow us on all our social media, Facebook, TikTok. What else?
We're doing the giveaway.
What else? Facebook, TikTok, X,
Instagram.
Instagram.
I think that's it.
That's it. Okay.
Oh, YouTube.
Or YouTube.
And then let them know that we're gonna be doing the giveaway next week.
Okay. I've also been told that next week is going to be our giveaway. Free consultation is going to be next week. So we hope to see you again next week. Until then, remember what I always tell you: stay out.